Today, we're going to dive into one of the most protected secrets in our entire society: what you tell your lawyer. It's a sacred vow, and honestly, our whole justice system is pretty much built on top of it. Just think about it for a second. That feeling of trust, right? Of knowing your words are safe with someone. It's a huge deal. Now imagine your freedom or your entire future depended on being able to share your deepest, darkest secrets with one person, with zero fear. Well, that's exactly the world our legal system tries to create. This bond of secrecy between you and your lawyer isn't just some nice professional courtesy. It's a fundamental cornerstone of justice. And this is what we're talking about when we say a lawyer's sacred vow. Seriously, it's not just a simple promise. It's more like an ironclad duty, a foundational principle that lets the whole system even work in the first place. So why is this whole thing so important? It's actually pretty simple. For a lawyer to give you the best possible advice, they need to know everything: the good, the bad, and yeah, especially the ugly. And you're only going to share that kind of stuff if you have an absolute guarantee that it is never, ever leaving that room. And listen, this is not a new idea. The Supreme Court of Canada itself called it this, which just goes to show you how deep its roots are in our legal tradition. This isn't just some rule, it's a right that's been fiercely protected for centuries. Okay, so here's where it gets really interesting. We tend to throw around words like confidentiality and privilege as if they're the same thing, but in the eyes of the law, they're actually two different, though related ideas. Let's break them down. First up, you've got the duty of confidentiality. Think of this as the lawyer's broad, ethical vow of silence. It covers literally everything they learn about you, from any source, while they're working for you. Doesn't matter if you're in a courtroom or grabbing coffee. And get this, it never expires. It lasts forever. Then you have solicitor-client privilege. Now, this one's a bit more specific. It's like a legal force field that protects the actual conversations you have with your lawyer when you're asking for legal advice. Its main job? To stop anyone, a judge, the other side, from forcing your lawyer to get up on the stand and testify against you. This table really lays it all out. Look at the scope. Privilege is pretty narrow, right? Just for communications about legal advice. But confidentiality, that's massive. It's all client information. And where they come from is different too. Privilege is a hard legal role made by judges over time, while confidentiality is an ethical duty that comes from the rulebooks that lawyers have to follow. So this shield of secrecy sounds absolute, almost unbreakable, right? Well, not quite. There are some very specific and pretty rare situations where the law actually says this silence has to be broken. And this is where legal ethics gets incredibly complicated. What do you do when keeping a client's secret could put someone else in danger? Or what if it could send a totally innocent person to prison? The law has to do this really difficult balancing act. These exceptions don't just come out of nowhere. They're carefully carved out from three main places: decisions judges have made in past cases, actual laws passed by the government, and the professional conduct rules that lawyers themselves have to live by. So, let's see how this actually plays out in the real world. We're going to look at some landmark court cases where these principles were put to the ultimate test, often with life or death stakes. Okay, imagine this. A psychiatrist is hired by a defense lawyer. In their sessions, the psychiatrist learns the client has detailed, violent plans to go out and hurt someone. That report is normally protected by privilege. So, what do you do? This exact thing happened in a case called Smith versus Jones. The Supreme Court ended up creating a super strict three-part test. To break privilege, the risk can't just be vague, it has to be clear. The harm has to be serious, we're talking bodily harm or death. And the danger has to be imminent, like it's about to happen. Only if you can check all three of those boxes can the secret be revealed. Now for another gut-wrenching one. Let's say you're on trial, and you're convinced that some emails between a key witness and their lawyer contain information that could prove you're innocent. Can you get your hands on that privileged file? The court in R.V. McClure said, yes, it's possible, but the bar they set is incredibly high. You can't just go on a fishing expedition hoping you find something useful. First, you have to show some real evidence that the secret info could actually help your case. Only then will a judge look at it privately. This is an exception that's saved for only the most extraordinary circumstances. Okay, this last one might be the most dramatic. A lawyer doesn't just hear about a crime. They're given physical evidence of it, say videotapes, showing their client committing horrific acts. This actually happened in the infamous Paul Bernardo case. His lawyer, Ken Murray, got a hold of tapes showing Bernardo's crimes, and he held on to them for 17 months. It created this massive ethical and legal firestorm. Murray's argument was that he was just protecting his client's confidentiality. But the court was crystal clear. This case shows a hard limit. Those tapes weren't a communication to get legal advice. They were physical evidence of a crime. A lawyer's office cannot become a hiding place for evidence. You can't conceal it from the justice system. Period. So these cases sort of set the stage, but the threats to this sacred vow are changing all the time. Today, the biggest threats might not be in a courtroom at all. They might be coming through a fiber optic cable. I mean, just think about it. Law firms are huge targets for ransomware attacks. We've all done it. That simple autocomplete mistake on an email could send privileged info to the wrong person. All those client files stored in the cloud can have vulnerabilities. And your laptop or your phone, full of confidential data, can be searched when you cross a border. The whole battlefield for confidentiality has gone digital, which really leaves us with this one final crucial question. This ancient principle, born in a world of paper and ink, now has to survive in an age of constant data breaches and surveillance. The duty itself hasn't changed, but protecting that sacred vow, well, that's more challenging and maybe more important than ever before.